Thank you for that wonderful question. When you talk about Nigeria moving towards a one-party state, I do not see it in that light because what we are experiencing currently in the country, we're talking about judicial interventions in our electoral processes. They are provided for in the Constitution. We look at Section 239 of the Nigerian Constitution 1999 as amended. We look at Section 285, subsection 2, Constitution 1999 as amended. In 65 of the Electoral Act 2022 as amended. The subsection 2 there says the decision of the returning officer, under subsection 1 may be reviewed by an election tribunal or court of competent jurisdiction and election petition proceedings under this act. So there are provisions made for judicial intervention, and it's up to the stakeholders in the elections to opt for judicial intervention or to ignore judicial intervention. And we have a precedent here. You recall that in 2015, when the APC, pushed PDP out of incumbency, that the leader then, the then president of the country, Dr. Goodluck Ebele Jonathan, did not choose to approach the judiciary for intervention. And he considered victory. So by and large, until we roll away that provision from our law, I don't see so. And of course, when you go for judicial interventions, then two parties cannot win at the same time. So one of the parties must win. So I think we should be discussing more about the credibility and the diligence with which matters referred to the judiciary are dealt with, because the judiciary also will consider the issues of law, the facts, the evidences, the witnesses, the exhibits, and different materials that are presented before the judiciary before coming to a conclusion. So I do not see it as rolling towards the one-party state, except those who are expected to diligently play the opposition, refuse to play the opposition.
Yeah, thank you, Barrister. As you said, for the case of Plateau, for example, looking at the appeal judgment, it talks about Plateau PDP not having a structure, having been having an high court judgment before the election, dissolving the Plateau PDP structure itself, that for them not to have a structure, they can't present a candidate for an election. Now, this itself looks like a problem of a party that is now being, and the citizen, for me personally, I'm looking at the citizen, the voters are now the one paying for this party problem. Should pre-election matters be a deciding factor? After elections have been held, votes counted and winners have emerged. Should pre-election matter be a deciding factor after elections have been held and winners have been decided?
Absolutely. You see, in law and in general principles of life, you cannot build something on nothing. Even in houses we live in, there must be a foundation upon which you build the house. Otherwise, the house will collapse. And like you also expressed, there was a judgment of the High Court to the effect that primaries have to be conducted. And the judgment was dishonored and disobeyed. And they went ahead to present candidates for the election. So what should people expect? And I just expressed my empathy about the electorate who appear to be innocent in all this. And what have the elders said? The elders said, when two elephants fight, the grass suffer. I just hope that we have stronger penalties for candidates of parties that choose to disrespect the decisions of courts. And then that is where we are. The principle of the rule of law stipulates that no one is above the law. For instance, if you are traveling to New York City, you have your visa, you have your passport, you paid for your hotel over there, and there is a precondition that, okay, when you are coming to the airport, please make sure you come with your passport. And you are saying, no, it's not necessary. You go to the airport and you are shouting on the officials there, showing them the receipt of what you have paid for your hotel in New York. That is not the picture. So if we are expected to comply with rules, let us comply with rules. And there are consequences. If you don't comply, as we say in law, everything built on that disobedience, they are referred to as null and void ab initio. That means from the onset. It's also like even what the governor of Kano State, who has now been asked to vacate for the governorship candidate of APC himself started doing. When he got into office, he started demolishing some properties, some for the argument that they did not have the requisite permit. So are you now saying that because those houses have been built before he came into office, he couldn't exercise the laws that says for you to build a house, you must obtain uh, the government permit? So it's neither here nor there. And when you come before the court will only interpret the laws. And as we speak today, position of the law is that a directive was given, which was fundamental to the whole process. So whether you did not present that to the electorate or not is a different thing. Though I buy into the argument that electorates should not be punished for the misdemeanor of politicians. And that is why, again, we have the National Assembly. And if you look at Section 4 of the Nigerian Constitution 1999 as amended, it stipulates that the National Assembly shall make laws for the peace, orderliness, and good governance of Nigeria. So let them look at all this and then come up with relevant amendments that will make our politicians obedient to directives of the court of the land, because no law has discredited the mandate handed over to the judiciary to adjudicate over matters. You look at Lagos State, for instance, Lagos State complied with the demands for structure and everything. So it's not really about which party is affected in this. It is about, have you done the needful before proceeding to get involved in that exercise? And I think in the past, some other parties have been affected too. We refer back to the case of River State in terms of primaries, conducting primaries effectively and things like that. So these are not sensational or sentimental matters. They are issues of law.
Yes, sir. Barrister, INEC as the umpire in our elections, are they not supposed to be gatekeeping such occurrence, even so that they don't feed ineligible candidates for elections? So all these are things I believe INEC should have gatekeep, so we don't have people that once there's a court judgment banning a party or a candidate, such candidate or party should not even be on the list at all for electorate to even make a decision from.
That is a gap on the part of INEC, and I quite align with your concern. Imagine that about 165,000 votes were wasted because they were considered invalid just because some electoral officers committed the error by not stamping them, even though stamping is also a requirement of INEC as part of their guidelines and regulations. So in this situation, there must be consequence. And that is why I keep emphasizing that we should tighten our laws to be wide in coverage so that we look at what we've gone through in our electioneering practices and, of course, try to preempt the likely hitches that may come up and provide enough provisions for such and consequences. So I really sympathize with any party that fell victim of this omission of INEC. Again, these are issues that could have been firmly pushed at the tribunal level before the Court of Appeal, claiming that the parties or voters should not be punished for the omissions of INEC. But having said that, on the part of the wasted votes, the issue of even having a candidate, legally so by virtue of our laws, is another issue that confronted the Kano election. So these are issues. These are issues.
Yeah, thank you, Barrister. Again, Barrister, I want to come from I want you to come look from the logical perspective now as a citizen, yeah. 3 judges upturning decisions of mass voters due to INEC error itself. How do you think of voters will feel in all of this?
It's not about how voters feel. That is what the law has provided. I mentioned Section 2A5, subsection 2 of the Nigerian Constitution 1999 as amended. It says whoever desires, that there will be a tribunal to attend to petitions challenging results of elections to various offices. And if you look at Section 239, it also covers that of precedents. So if these tribunals are there, the law has also stipulated how many justices should sit on these cases. And I think for the petitions during this last election, about 436 judges were set aside to attend to them, for you to know the number of petitions before the tribunals. You see, and of course, at the tribunal level, you have 3 justices. And at the appellate level also, you have 3 justices. And when you move up to the Supreme Court level, which is the apex court, you have 5 justices. Interestingly, these are in line with the provisions of the law. And I mentioned this earlier, that if you don't come to the judiciary has nothing to adjudicate over. And judiciary cannot now say that because petitions are before them, then they will now bring 75 justices to sit over this petition. So there are stipulations of the law. So what the National Assembly can do, and perhaps the state houses of assembly, is to look at these laws and amend. And I'm happy that right now there's a discussion going on. I read recently that the issue of transmitting results live, to the IRED should be made mandatory. They are considering the issue of diaspora voting. And you reflect this in our laws. Let me say this. Majority of those who are complaining about judiciary, about INEC, and some of them are already in the National Assembly, or their parties are represented in the National Assembly. Then when you get there, what some of us expect is that your concern should be to upscale these laws, to reduce the gaps that are presently there, because you're expected to enhance the fortunes of the society. But is it not that when some of these politicians get their victory, they are more interested in their personal benefit than to amend the laws to represent the general interest of the citizens? And again, talking about the tribunal on your need to have victory there, if you look at Section 131 of the Evidence Act 2011, it says clearly that whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts shall prove that those facts exist. It is not the court or the tribunal that will prove your case for you. And in the precedents of the Presidential Election Tribunal, this 2023, I think there were about 89 senior advocates of Nigeria that came representing different parties, those petitions, and of course, in company of other lawyers. And if we put their practice experiences together, it should be over 100 years of experience. So, and you I'm sure would have monitored when the final decision were being read, particularly at the presidential election petitions, and you heard how the justices were expressing their concerns about some of the lawyers abusing the rules of court and things like that. So if the rules are clearly spelled out, you have to face them in law. It's about facts, witnesses, evidences, your your exhibits and everything you have to present before the court. It's not sensational. It's not done online. It's not about public opinion. So as we speak right now, the Constitution has empowered the judicial structure we have. And I read the comments of Olusegun Obasanjo, which of course sound sensible, that it's a dangerous thing to allow, for instance, 3 men, the tribunal, to decide the fate of many electors. But interestingly, that is what we have for now. We have the legislators who are well paid and well equipped to look into these laws and amend the laws. And there is no law that says our laws cannot be amended. And in the absence of that, I want to advise that nobody should will as the consequences. And we all know that if 3 parties go to court claiming victory, it's only one party that will win that victory based on how you push your matter. And some have argued that technicality should be removed. How can you remove technicality from substantive judicial interventions? It's just like saying now that the need for midwife to cut the umbilical cord is not necessary. No, not at all. There are rules, there are procedures, there are technicalities. When you buy a vehicle, the substantive purpose of buying that vehicle is to move you from one location to the other, but the technical aspect of it is that it must be well maintained to enjoy maximum performance. And if your car engine is a petrol engine, you cannot just wake up and say, oh, diesel is liquid also like petrol, and you fill that car with diesel. Definitely that engine is not likely to cooperate with you. So these are issues. So let me underscore again that the law is not about sentiments. The law is not about sensation. It's about presenting your facts and proving your case. But I'm glad also that even for some of the cases that have moved from the tribunal level to the appellate level, the opportunity is still there to approach the apex court in the land, which is the Supreme Court of Nigeria, that became the highest court since 1963 when we became a republic. And you have precedents of those who have gone all the way. And of course, victoriously so. The present governor of Osun State, Adeleke, went all the way to the Supreme Court, and he won. At the tribunal level, his victory was upturned based on overvoting, and he appealed to the Court of Appeal, and the Court of Appeal could not see how those alleging overvoting will prove it. So they could not prove it before the Court of Appeal that there was overvoting, and that is when you read that the case lacks merit, and they upheld the victory of Adeleke, and the matter went all the way to the Supreme Court. And the Supreme Court upheld that victory. So when you talk about justice at the governorship level, you have 3 levels: tribunal, the appellate, and the Supreme Court. And when you talk about the presidential election, you have 2 levels: the tribunal being at the appeal court level, and finally the Supreme Court. And we have also tested that in the case of President Bola Ahmed Tinubu, Commander-in-Chief of the Armed Forces. So we can learn from all this. And interestingly, a critical issue that was going wild online, the internet, was the status of Abuja. But again, the Supreme Court has interpreted the provisions of the Constitution on the status of Abuja, stating that Abuja has no superior status over other states in the country. So that is the role of judiciary, to interpret the law and come up with decisions.
On a final note, Barrister, with these judgments, how would you rate 2022 electoral laws?
The laws are being put to test. For instance, there was a provision in the Electoral Act 2022 as amended that political appointees who intend to actively contest at the primaries must resign. And some resigned. The likes of Amechi resigned. He wanted to resign, but he backpedaled. So that has been put to test. So the issue of beavers has been put to test. And the issue of iron has been put to test. And the decision of the court is that IREV is not a collation equipment. It's just like a storage equipment to which the results must be transferred. And I'm sure that by now, for those who care to visit the IREV, the total results must have been provided, because we also need to look at the global issues in Nigeria. Do we have the facilities, effective facilities, to support some of these new introductions? So, and you know, it took a long time for the Electoral Act to be finally amended. So there are still issues to engage there. For instance, that Section 65 of the Electoral Act 2022 as amended, the senior civil Pepun complained seriously that it's a dangerous one because, and I agree, because what that Section 65 says is that the decision of the returning officer shall be final on any question arising from unmarked ballot paper, rejected ballot paper, declaration of scores of candidates, and the return of a candidate. You know, provided that the commission shall have the power within 7 days to review the declaration and return where the commission determines that the said declaration and return was not made voluntary or was made contrary to provisions of the law. So you see the wide discretion given to INEC there. And after that, the one I referred to earlier, that those who are not eventually satisfied with the returning officer under the subsection 1 may now go to an election tribunal or court of competent jurisdiction. So our laws must be reviewed, and you fine-tune them. Like I have mentioned now, if the omission of INEC has caused a governor to lose his vote, then I expect that his party representatives at the National Assembly and at the Senate should rise up to the occasion and look at the laws that we have that will not punish INEC or prevent the omission of INEC from nullifying the vote of innocent electorate. So these are issues. So the National Assembly is not a place for merriment. It's a place for, like I mentioned earlier, making laws for the peace. Peace is sacrosanct, good governance, and for the orderliness in the country. So these politicians are fully represented, you know, in the National Assembly and state houses of assembly. So let them make record type laws, and let those who are expected to execute the laws execute the laws. During these staggered elections in Kogi, Bayelsa, and Imo State, there were electoral offenses committed. And so will those defendants, like we call them, under the new dispensation of criminal justice, will they be punished if found culpable? You know, will they even be thoroughly prosecuted? So these are issues, the situations where people walk away with offenses and crimes in the land, then we are reinforcing disorderliness. You know, and when you look at industrial psychology, that's what we call reinforcement theory. So if you don't punish them for it, they get worse in that practice. So Nigeria should wake up and come to the point where the citizens, whether in government or in the governed circle, submit themselves to the prevalence of the rule of law and then decide to play by the rules. So when we get to that point, I think we can stand up and claim to be practicing ideal democracy.
Thank you, Barrister Ologun, for joining us today. Hope to have you again next week. Thank you, sir.
Thank you very much. God bless Nigeria.